Hello and welcome to the next episode of Mayor Brown's video series at the Crossroads, CFTC and DOJ Enforcement. My name is Matt Kluchenek, a partner at Mayor Brown and a member of Mayor Brown's Litigation and Dispute Resolution Group. And I'm joined by my partner today, Glen Kopp, a former federal prosecutor out of the Southern District of New York and a member of Mayor Brown's White Collar Defense Group. As you may know, each week we seek to bring to you an interesting topic that concerns CFTC and DOJ enforcement. And today we're going to talk about cross-border enforcement. So Glenn, turn it over to you here. And the situation is you've got someone located outside the United States who is or believes he or she or the firm is a target or a subject, maybe a potential witness. Talk to us a little bit about the process from a DOJ perspective that follows next.
Absolutely, Matt. So yeah, we've talked a lot about the sort of expanding universe of the jurisdiction of DOJ and the CFTC and their reach abroad when it comes to prosecuting fraud cases in particular. And so DOJ is able to get at evidence abroad mainly through what's called the Mutual Legal Assistance Treaties, or MLATs. And DOJ has, these are sort of bilateral agreements for sharing information from one country to the other, law enforcement related information, oftentimes in connection with investigations. There are upwards of, I think, about 70 treaties that exist right now. And so that's a pretty involved process that DOJ has to go through to get such evidence. And that evidence could be documentary evidence. It could be testimony from witnesses. There are a lot of things that you can get through the MLAT process, but it's a lengthy process. It requires a prosecutor to put together a request that fits the requirements of the particular treaty. It has to be reviewed by the Office of International Affairs for DOJ, which is the central authority that manages this process. And once the request has been approved by OIA, it then gets translated, if necessary, to the language of the recipient country, and then transmitted to sort of OIA's equivalent in that country to then get executed by the local law enforcement in that country.
And Glenn,
yeah, go ahead, Matt.
Lengthy process. So does that toll the statute of limitations period?
Oh, great question. So if you are going to go through the MLAT process, the government, the DOJ does have an avenue to toll the statute of limitations. They have to submit a request to a judge. It's ex parte because there's no sort of other party at this point in the investigation phase. So DOJ would have to make a request under 18 U.S.C. 3292 to toll the statute during the pendency of the MLAT request. And DOJ is required to make a showing by the preponderance of the evidence that they're making this request because they believe that there is evidence abroad relevant to the request. And so once they do that and a judge authorizes the tolling, the statute will be tolled for up to 3 years. And that sort of the tolling would start when the order is issued, and then it would end presumably when the evidence is provided by the foreign country. And so it's a really important, and I'm glad you brought that up, Matt, because we've seen this be a major issue in international fraud cases that are brought by DOJ because they're pretty complicated cases. They can take a while to investigate. DOJ has looked at some pretty old conduct in some of these cases dating back to 2010, 2009. And so you can imagine if you're facing a 5-year statute, you're under a lot of pressure to get that tolling request authorized so that you can get your evidence and review it and then decide whether or not you're going to bring charges. So we've actually seen some challenges recently in some spoofing related cases to the MLAT process being used as alleged as a pretext. So challenges saying, this is not really a valid request. It's being done solely to stop the statute. And courts are reluctant Matt, to look into sort of pretext challenges, because really what you're talking about is what's in the head of the prosecutor. And as long as the prosecutors have satisfied, at least according to the courts, as long as the prosecutors have satisfied the requirements of the statute for tolling, courts are not inclined to look into what the motivation was for the government. So those challenges have not been particularly successful, although at least in one case, the Bagusi case, the DOJ was able to sidestep the issue in some ways by bringing charges or dismissing pending charges that had a 5-year statute. So that would have required the tolling to be valid for the charges to be made. What they ended up doing is they dismissed those charges and then superseded to add charges that had a longer statute of limitations, I think the 10-year statute. And so at that point, the challenge was really mooted and there was no need to have any evidentiary hearing on the challenge, the pretextual MLAT challenge. And so Matt, that's a little bit about the DOJ MLAT process. What kind of process does the CFTC use to obtain evidence abroad?
Thanks, Glenn, and thanks for your insights. I know when you were at SDNY, you drafted a lot of those MLATs. You've seen all the defenses, so great to have you as a resource on that topic. From a CFTC perspective, we have seen incredible ramp up in cross-border enforcement between the CFTC and its non-US counterparts. Frankly, it's more significant now than we've ever seen. We're seeing in particular a lot of interaction between the CFTC and the UK Financial Conduct Authority. We're seeing cross-border efforts, CFTC regulators in Germany, Switzerland, even parts of Asia. And the tool that is used for the CFTC with respect to its cross-border efforts, quite frankly, quite a bit easier than the MLAT process. That tool really takes the form of a memorandum of understanding, an MOU. And the CFTC has, over the last number of years, negotiated more than 20 MOUs with regulators around the world. And the MOUs are fairly prescriptive, really go through and do a good job of defining what the process is for requesting assistance, what information can be gathered, so on and so forth. All of these MOUs are publicly available on the CFTC's website. So that's been a really, really useful tool for the CFTC to harness, quite frankly, cross-border enforcement collaboration and efforts. And so we expect no abatement in that respect anytime soon. In fact, more recently, the CFTC has been inclined to tout, if you will, or promote the efforts of non-US regulators. And we'll see references increasingly in consent orders, for example, with recognition going to the non-US regulator. Certainly requires a lot of raises a lot of interesting issues when the CFTC, for example, is seeking documents through the FCA that in turn reaches out to the firm and an individual, and you kind of have this circuitous route that goes back and forth. Sometimes, depending upon the circumstances, we may try to truncate that and actually deal directly with the CFTC. Sometimes that's not necessarily in the client's interest, but there's a lot of factors to consider when we're thinking and talking about cross-border enforcement. So, Glenn, back to you. Give us a takeaway. So that scenario again, where someone's overseas, subject target of an investigation, that calculus, and a couple of takeaways would be great.
One of the big takeaway, Matt, is that if you do become aware of the fact that there is a process out there looking for materials from you as an individual or in connection with your work, don't hesitate to pick up the phone and call a lawyer. There are challenges that you can make to these requests, but even if there are no challenges, you after a lawyer has reviewed the requests, you definitely want a lawyer to walk you through that process, because just being abroad doesn't mean that you are outside the scope of the ability of the U.S. to ultimately potentially bring charges against you. But you really want to make sure that you respond to these requests sufficiently and appropriately. And so having the advice of a lawyer is really, really important.
And perhaps, Glenn, just to add to that, really important too to have a lawyer, not only a U.S. lawyer, but also a lawyer in the local jurisdiction, and for there to be coordination and collaboration, because issues likely are going to arise, be implicated in both jurisdictions. So having counsels, at each place is really important. And the other thing I'd add, very large topic, but just something to bear in mind, is that of privacy rights and privacy implications in terms of certain potentially jurisdictional restraints or prohibitions. And so something not to be overlooked in the context of these processes. Another important piece of the equation here deals with extradition, and we saw that prominently several years ago in the Navinder Sarro case, where the authorities sought to extradite Mr. Sarro, and extradition is something, it's a hot topic. It's been particularly controversial in this space, and so Glenn and I plan to cover that in the near future. For today's session, that concludes it, and thanks to everyone for watching, and we look forward to seeing you again. Thank you.